I focus my practice primarily on education technology, and I think we currently work with about 110 different districts through our Education Technology Pool Council on advising districts about technology issues. And so what we have prepared today is kind of a hodgepodge of a couple different issues that all really relate to student privacy and student information. And certainly, Zoom meetings and webinars and things like that make it a little harder to ask questions. I'm happy to answer questions if you have them, whether via the Zoom or via the chat function if you want to send me questions. I'm fine with that. The URL that's on the front of the first slide is a public copy of these slides. So if you have that, it's tinyurl.com /WIU Jan, Jan 21. Today's January 21st. So WIU Jan 21 is the URL, and you can feel free to have those slides and reference those to people in your districts if you need to. The overview of the issues that I wanted to talk about and start with, one of the things that Eric had asked about and that I definitely want to cover is COPPA, which is the Children's Online Privacy Protection Act, which I feel pretty confident in saying no one is doing correctly. So we'll have some ground to cover with that. Happy to take any questions on that. Then want to get into student records and what is a record, and when we use an app, is that a record, and things like that. So that will be covering some ground that you may have been over before with some training on FERPA and HIPAA and right to know and things like that. But I want to approach it kind of with the lens of electronic information and where we're storing information and how we're storing information. And then the last thing I wanted to talk about today with student privacy and student data is having to do with searching devices, and when it's a one-to-one device and what's stored on the device, when we can search a student's mobile device, and if it's a one-to-one device, does that really change things? So if we have any extra time, I'm happy to answer any additional questions that we have. But starting with COPPA, which is the Children's Online Privacy Protection Act. Pretty much there's a whole mess of technology laws that start with C, have a P in it, and end in an A. So it's hard to keep track of which one's which because they're both state and federal laws. This is a federal law about children's privacy. And the basic of this is this was 1998, the early days of the internet. Congress wanted to protect young kids. So these are kids under 13 from sharing too much information online. So what the law is designed to do, it's not supposed to apply to school districts. It's not targeted towards schools. It's targeted toward commercial websites and commercial apps. So anytime one of those commercial websites or commercial apps collects personal information from a kid under 13, parent consent is required. So there are new regulations that just came out in 2013. So this law is actually pretty up to date by our technology standards. But if an app collects any personal information from a kid under 13, parent consent is going to be required. So that could be just a name and address, things that we think of as personal information, or it could be as limited as just geolocation, or it could be as limited as just a screen name, because the regulations take into account the idea that a kid's going to use the same screen name over and over again, or the screen name is going to be connected to their name in some way. It's going to be identifiable. So the way I keep track of this in my head is pretty much if anytime you're going to have to register for a website, anytime there's going to be a username and password, anytime there's going to be some sort of identifier attached to the kid, COPPA is going to be in play. And then what the law is supposed to require is what's called verifiable parent consent. So it's supposed to be not just, oh, hey, yeah, parent consent's click. It's supposed to be verifiable in some way. So the law generally targets commercial websites, meaning things that have advertising, things that are trying to generate money, paid apps, things like that. But it does apply to general audience websites that collect information too. So it could just be an app that is just intended for the general public, but it's collecting information. So unpacking that a bit and how it really applies to us and how it usually applies is if a kid's over 13, we're not worried about COPPA. So for the vast majority of middle school students, high school students, COPPA is not in play, not a big concern. But how it's supposed to work is students 13 and over can register for any interactive websites, any Web 2.0 apps, anything like that. They can just register on their own. But if a kid's under 13, the website itself is supposed to stop them and require parent consent. The parents are supposed to read the privacy policy, say, okay, I see how you're using my kid's personal information, and then the parents approve. So you can kind of see how this gets to be a problem from an educational context when we want to go register kids for websites, or when we want to use a certain website or app and it gets bogged down in this parent consent process. So even though our general presumption is COPPA doesn't apply to schools, it is a huge factor for teachers, for technology staff, and for administrators to try to figure out how do we legally get through the door to start using these apps, because we're getting stopped asked for parent consent. So there's really three issues here, and I'm going to unpack each one. So the first one is teachers registering students under 13. So anytime a teacher goes to get their kids using a certain app, if the kids are under 13, the teacher needs to be aware it may ask for parent consent. And if the website is asking for parent consent, the teacher can't just click and say, the parent consents, if we haven't actually gotten parent consent. Now, think about this in the same way as like a field trip permission slip. Would a teacher sign off on a permission slip and said, oh yeah, the parent gives consent, if the parent hadn't actually give consent? Say, no, of course not. Teacher can't sign off on a permission slip under some theory of in loco parentis or something like that. You can't just sign off on a permission slip unless we actually have consent. And so if you pay really close attention to the guidance that the federal agency in charge of COPPA gives, they say, well, yes, schools can agree on behalf of parents to these websites. I agree. Schools can agree on behalf of parents so long as the parents have actually given consent first. Otherwise, we're really forging consent. It's a state law problem of forgery that we're agreeing that the parent has consented when they haven't actually consented. So this is annoying and it's cumbersome, but for these websites for 12-year-olds, 11-year-olds, and things like that, if we are using a username and password, if it is collecting personal information from the kid, like their picture, their geolocation, or things like that, the website itself is going to require us to get consent. And our teachers can't just go through and click for all 30 students in their class and say, yeah, we consent. And so that's the issue here, is teachers consenting for students. There are some exceptions. So you think about the types of products where the school district contracts directly with the company. It's not a commercially available website or something, it's not just a commercial website that you go to and there's advertising, but say like a Blackboard product, or the Google product where we're registering a kid with a username and password in order to give them email. Those things are all exempt from this type of thing. Those websites aren't going to stop you and say, wait, we need parent consent. So really, it's not our problem to look at every website and say, is this one, requiring parent consent or not? But if it stops us, if it stops our teacher and says, do you have parent consent because this child's under 13, then we can't just consent unless the parents have gotten consent. So how do you do that? We've recommended that school districts identify a list of all the approved sites that are kind of like their stock ones that they're going to use, and they get a blanket parent consent for all of those different resources. It doesn't necessarily prevent a teacher from using an additional one if they get parent consent for that, but we kind of start with this, okay, here are 15, 30 websites that we commonly use, apps that we currently use that require parent consent, and here's a link to all their privacy policies. So that's issue 1 on this page, is teachers registering students. Issue number 2 is more specific to some contracts, and a lot of you may not be in the business of having to read all these contracts, that they get vetted by someone else. But a lot of these contracts will delegate COPPA compliance to the district. So let me give you an example. When school districts are Google for EDU districts, it comes with the core apps of Mail, of Calendar, of Google Docs, Google Drive, things like that. That doesn't require parent consent because there's no commercial advertising or anything like that attached to it. It's just direct between the district and the company. And so Google doesn't require parent consent in order for you to get that, get the username and password for each of your students, even if those students are under 13 years old. Doesn't matter, you don't need parent consent. But in the fine print of the Google agreement, it says the school district or the IU assumes full responsibility for COPPA compliance, including securing the necessary parent consents. So in this situation, the core apps that are associated with Google don't have any commercial purpose, they don't have any advertising, you don't need parent consent. If your district adds the full interactive features of some of the optional apps that are attached to Google, like YouTube. So you're not just adding the ability to view YouTube videos, but you're adding the ability to log into YouTube so that your students can post content, that they can rate videos, that they can give thumbs up or thumbs down, that they can comment on videos. If you add that, if that's an option that you add in the Google console. YouTube is a commercial product. It has advertising on it. And at that point, you've crossed into the needing parent consent threshold. And so in order to comply with COPPA, technically, because of this contract, the school district is responsible for getting parent consent. Now, this is why I say pretty much no school district is doing this accurately. Google doesn't prompt you before you give those YouTube permissions. It doesn't say, warning, now pursuant to our contract, you're responsible for going out and getting parent consent. No one's telling you to do that. No one's really telling you how to do that. But according to the terms of the contract, you've agreed to comply with COPPA, including getting the parent consents. And by adding a website, meaning YouTube, to this product, you've now implicated COPPA, and you're supposed to get the parent consent. So this is pretty much never done in school districts. but I'm telling you what the law says and what you should be doing to comply. And at the very least, before you go and you add new features or you add a website, there has to be a careful vetting process. And then the third issue, I kind of mentioned this, the third-party providers, whether it's Blackboard or Moodle or something like that, if it's just a direct agreement between the district and the company, or the district's just directly purchasing some product, parent consent is not needed unless it's required. So there are going to be some apps, there are going to be some things where parent consent isn't required. So looking at all of this, it's really quite complicated to try to figure out if COPPA applies. Remember, if the kids are 13 or older, you don't even have to worry about it. But with your younger kids, you really need a process of vetting apps and vetting websites before your teachers start using them, if it's going to require one of these features. So in practicality, how you're going to implement this, what are the things that you can do that you should do? Well, one is you got to read the fine print on some of these contracts, and it's annoying to get into it, but the user agreements, the privacy policies, things like that, with these huge software companies, you don't have a lot of bargaining power. You don't necessarily have the ability to go to Microsoft or go to Google and say, hey, I want you to rewrite your contract. So you have to read the contracts carefully, make sure you know what you're getting yourself into and what you have to do. The second thing is, I recommend that for those younger kids, you develop a list of approved web resources, a list of approved apps that they've been vetted through both curriculum to make sure it's tied to your curriculum, and it's vetted through technology or your business office to make sure the policies are in order. And then you just get blanket consent. So that could be through a website where parents go and they see all the URLs and all the websites and they give their consent. It has to be verifiable. It doesn't say it has to be written consent. So you could do that through some sort of web form or something like that, but it is cumbersome to get parent consent for those different apps. You certainly can allow additional web resources. You know, if your teacher goes to a conference in February, comes back and says, this is a great math app, I want to start using it, no one's saying you can't, but if it requires registration, we may need verifiable parent consent prior to going forward with that. The big thing that technology staff have to know, but above all, teachers have to know, we really have to communicate with teachers, is that you can't sign that a parent has consented unless we actually have parent consent. We don't want to forge parent signatures unless a parent has actually given their consent. So in practicality, that's an important step that we need to pay attention to and make sure that we're educating our teachers about that so that we're not unwittingly committing forgeries or things like that. So a couple points just to finalize this, and not to put too fine a point on it. The Federal Trade Commission is the federal agency responsible for implementing COPPA. And they recently brought a case against Yelp. And you don't really think of Yelp as being, a bastion of privacy violations, that this is collecting tons of personal information from kids and it's such a great threat. But what the FTC discovered was that Yelp on its website had a system for catching kids who are under 13 and making sure they had parent consent. But on their app, they did not. So they had their app and they had advertising on their app, but they had kids under 13 who, I don't know if they were writing nasty reviews of Chuck E. Cheese or what they were doing on Yelp as a 10-year-old or 11-year-old. But ultimately, FTC wasn't messing around with Yelp. And then ultimately, they reached a settlement of $450,000 for this violation. So they are not messing around when it comes to coming down on commercial websites for violating this. And there is part of the COPPA law that allows the state to bring actions as well. And that's happened a couple times in New Jersey, where New Jersey consumer protection agencies have brought actions against websites operating without getting the right parent consent. But ultimately, one of the things that you can see on this screen here, in the bold print about the middle of the page, it says COPPA coverage may be broader than you think. It isn't just for kids sites. So, just because it's not child related, it's time to rethink. So some of the websites that we use, or apps, and the big thing is apps too, may just have kids go on and they just open the app and they practice math, and then that's it. That app shouldn't require parent consent. It's not collecting any personal information from kids. But if we go to a math practice app and it has us log in with the username and password so that that kid's mathematics performance is tracked over time, we know how many they're getting right over time, we know what they're getting out of it, which quite frankly is probably a better curriculum tool going forward. It may be that that website does require parent consent. It's really not up to us whether it requires parent consent or not. It's on the website to decide. So if that's the case, and the website does require parent consent, we're going to have to get that parent consent. So it's really not up to us to choose which websites are going to require parent consent or not. It's more just a matter of the website making sure they're complying with COPPA, and then us responding to it. I think there's one more slide on this. Yeah, FTC warned another app maker, which is called Baby Bus. And this is common too, just sending letters to developers saying, hey, you're violating COPPA. You need to get parent consents before collecting any information from a child. So a couple final thoughts about COPPA. Sometimes we don't necessarily consider what all is collecting personal information from a kid. So an example I like to think about is Google Earth. Google Earth kind of seems like one of those websites that you just go to. It doesn't really collect information and you just use. But keep in mind that your geolocation only is personal information under COPPA. So if Google is collecting your current location, they should be requiring parent consent in order to use that product. So I don't pretend that this is really simple and straightforward. I think it's actually quite cumbersome and difficult. But the advice that I've given is generally limited to these practical applications. Reviewing your contracts, and then trying to find a list of, okay, all the ones that we do use that require parent consent, listing them all in one place and getting the parent consent once. Because that's far more efficient than kind of doing it each time as those different issues come up. Are there any questions about COPPA?
Yeah, I've got a question.
Yeah.
So if geolocation comes into concern, if you have a mobile device management system like Meraki, for say, that does track location, do I have to get parents to consent to that?
No. So that's just something that the school district has chosen to use to manage your devices or to manage the devices that are on campus. You don't have to get parent consent in order to use a software application, or even if it's a web-based application or something like that. What they're targeting is ones that are, commercially available apps or commercial apps that are trying to collect the location for kids under 13.
Okay.
That's a good question, though. Any other questions about that? All right. Hearing none, unless someone's typing in the chat. I'm going to go in the next section, which is student records and some confidentiality issues in data management. And kind of in order to go through this, I kind of figured out that the best lens to do this is through the records laws, and to talk about, you know, what is a student record and when we may have to provide it. So first, going to just cover some territory that you may have heard before with FERPA and what FERPA is. The Family Educational Rights and Privacy Act is the student records law that covers all student records. It's way outdated. The regulations are way outdated, and it's really not up to date for our modern needs. So keep in mind, FERPA is just one of a series of different laws that may apply when we have student records. We've got FERPA, we've got HIPAA, which I'll talk about briefly, right to know law, the Federal Rules of Civil Procedure. These are all different laws that may require you to turn over records. And the short version of many of these laws is generally, if we have a record, and if we have an electronic record, we may have to turn it over upon request. You know, all those laws together, it's kind of what they say. But for FERPA, it's a very functional law that is designed to allow students and parents to inspect their kids' records. So educational records, and this is an important definition, are records that contain personally identifiable information about a student and are maintained by the agency or a person acting on behalf of the agency. So it's a very broad definition, and most districts have an educational records policy. It's like a FERPA type policy. We have a model one with our pool council that specifically identifies what is an educational record and what's not. And this becomes really important to nail this down in your policies so that you're clear up front when someone says, I want your text messages between the principal and the teacher about this kid. Is our text messages a student record? And ultimately, if we don't have it clear in any policy, we're left with this definition, which is, does it contain personally identifiable information, and is it maintained by the agency? So what we can do is we can lay out certain things that we don't maintain under FERPA. We can say we don't maintain text messages. We can say we don't retain voicemails. We can say we don't retain Post-it notes or fax cover sheets or anything like that. We can say we don't maintain chat logs if you use chat in your district. And ultimately, by not maintaining some of these things, we can exclude from FERPA inspection some of these more difficult records, ones that we can't necessarily maintain or that we're not able to readily recover. So as we're looking at the definition of different FERPA things, keep in mind a person acting on behalf of the agency will mean our contractors, and that may mean some of these websites that we're using for kids. So for an educational website, like I was talking about for math, where you log in and it's tracking the kid's performance over time, if it is a, student performance data and it is tied to that student's identity, whether through a username or a student ID number or something like that, it's going to meet the definition of a FERPA record. So oftentimes, and I also work in special education litigation, oftentimes when we get a student records request, people will go to the hard copy file or they'll go to the IEP writer file or something like that, and they'll just print out all the documents. People are entitled to, parents and students are entitled to the entire student records, which could mean all of the documents that are stored in the various apps that we're using. They're stored in the various databases we're using. So if the nurse is using a database, If it is personally identifiable information and we're maintaining that, that database is a student record. Ultimately, the questions with different types of records are going to come down to this definition. So it's very broad and generally consumes most types of things as long as it has some identifiable information about a kid. So using your policies to narrow that can be an effective strategy. There are a couple of things that the law says are not an educational record, one of which is records kept in the sole possession of the maker as a personal memory aid. So that could be online. You know, if a teacher keeps notes about their particular interactions with the parent in some sort of online form or something like that, if it's kept in their sole possession, it's not an education record. So one of the things also about whether it's an education record, we have to consider emails and documents stored by individual users. Are those emails going to be education records or not? So I'm going to talk about that in a second. So some examples of things that definitely are FERPA records. This should come as no surprise to you. All these different things: students' cumulative file, special ed records, emails, maybe. I'll talk about that in a second. Student work product that we are keeping, counseling notes, pretty much anything that's in your central database, like report cards, attendance, things like that. So it doesn't really matter where the record is located. The law no longer is, oh, well, it's in his file, therefore we're maintaining it. It doesn't really matter what the purpose of the record was. It doesn't really matter who created it or whether it has anything to do with education. If it contains information and it's maintained, it's going to be a FERPA record. So some of the things that I mentioned already: student performance data in an online website, yes, a potential record. When we talk about Blackboard or Google Classroom or some kind of classroom management software like a Moodle, what about the information that's stored on there? If it is personally identifiable and it is maintained, whether by Blackboard or by Google or by us, it's going to be a student record. And the same thing for student work product. So, you know, if teachers are using a particular forum, like say they're using Blogger to have their kids blog, you know, in theory, all of the things that are stored there online are education records.
Can I ask you a quick question about that?
Yeah.
So let's say we have students who are participating in a blog or an online forum, but the teacher has them use maybe their initials instead of putting their name on it. Is that still considered personally identifiable, or is it that not at that point?
It probably is still personally identifiable. So, you know, like with my kid, they've given him some crazy generic username that has no relation to his name for math website, but they know that that's him. And so it's ultimately, it's not publicly available to know who it's tied to, but because the district knows who it's tied to, yes, it is personally identifiable for that kid. So, yeah, even if it's a generic username or whatnot, yeah, it could be subject to a request. And this isn't to say that this is going to happen every time, but this is just kind of getting, as we think about student privacy, this is just getting our head around what all are student records, because we've kind of gotten away from this simple idea of things in a file versus things out of a file. So it's kind of just getting our head around it.
Thanks.
Sure. Any other questions about that stuff so far? So just a couple other random things about FERPA. Parents and students can not just request to inspect records, but they can also request to change or alter records. And that can be really tough with some of these online options. It may not be possible all the time, but we have to respond within a reasonable time to one of these requests. And this is usually laid out in a FERPA policy or education records policy by most districts. you can only request and inspect the student's own records. So if other kids' information is commingled with that, we have to redact that. So these requests for education records, those of you who have a lot of special ed litigation in your district certainly know, it's very common statewide to get requests from parents, from advocates, from attorneys, requesting the student's entire educational file. And so they'll generally just say, we want all of the records. And ultimately, someone has to make a determination about what to send. And whether that is the technology director, the pupil services director, the special ed director, or all of them working in, in consultation with the attorney who's working on it, determinations have to be made as to what is a record and who's going to bring that. So part of this session today and educating you about this is to prepare you to say, well, what about this? What about that? Thinking through the different resources that you have, the different places you're storing information, because it's not as simple as just giving the special ed file. It really is the different places where you're storing information. So as applied, let me work through a sample and then I'll kind of talk about some recommendations. So a parent suspects that a principal's been speaking poorly about a student behind his back, and he may have even been bullying the student for being too feminine, being a girl. So the parent sends a handwritten note to school requesting all emails about the student. Is this a FERPA request? Well, there's no reference to FERPA in the request. Do we treat it like a FERPA request? Well, if we haven't identified in our policy how we're treating emails, the question is, does it contain personally identifiable information about a kid? Yeah, it would. And is it maintained by the district? Yeah. So you're stuck with that being FERPA records. So leaving paper records aside, how do you go about doing that? Is the district running an email archiver? Are you just, if not, are you just left looking at emails stored on servers? Are you doing a manual search in sent folders, in deleted folders? And ultimately, how are you going to determine the search terms? So this is usually where I recommend you consult with whether your solicitor, your special counsel, whoever's might be related to the matter, to determine the search terms. I usually recommend using the student's full name or their nickname and the parent's email address, because the first way parents know you haven't provided all of the emails is because they know that they emailed you and their email is not included. So using those terms are usually pretty effective. But this is one of the principal reasons why an email archiver is nearly essential for any district that's receiving these requests, because going through all the different folders on the server is really time-consuming, and it's frustrating, and even at the end, it's hard to verify that you've gotten everything, that you haven't missed something. For these emails that the parent has requested, if there are other students' information contained on those emails, those are going to have to be redacted to remove information. It's very common for teachers to talk about 3 different students in the same email. So you have to delete the information about the other kids or redact it out of there. And then sometimes teachers do print out emails and they save them in hard copy or things like that, and those would be at issue too. Those would be subsumed into the archiver if you had an archiver. So ultimately, this is a pretty mundane request from these parents. We want all the emails, but it could send you on a wild goose chase trying to track all this down, depending on how you've defined what a FERPA record is. So a second example in this, so parents very unhappy with their kids' special education programming and has got an attorney. The attorney sends a letter requesting any and all records that relate to the student. And it doesn't specify emails at all. So do you proactively do the email search and provide all the emails and things like that. And this is where it gets a little complicated. So in our student records policy, we have a model student records policy for our pool council, and we have said that personally identifiable electronic information, including email, is not considered to be maintained by the district unless and until it is moved to or stored in and on a student records maintenance site. All right, this is complicated, but what this means is all of that electronic information that we have out there, including emails, but electronic information like, you know, the First in Math website, or, you know, this reading website where they're working on phonics, all of this electronic information is not maintained by the district until it is moved or stored on a student records maintenance site. It's the equivalent of saying we're not maintaining things until we save it in a file. And it's trying to cut down on the number of things that are subject to FERPA, that are subject to these voluminous requests. So if you are running an email archiver, you may be keeping your emails for 2 years. You may be keeping your emails for 3 years. But technically, according to FERPA, if you exclude it from your policy, you're not actually maintaining it. So this is a complicated scenario of cognitive dissonance. You are maintaining it, but you're technically not maintaining that. Excuse me one second. But you're not maintaining it. So you can
Can I ask you a question there real quick?
Yeah.
We're not maintaining it for purposes of FERPA, but it would still be maintained for purposes of open records requests.
Right.
Although you would release student information in an open records request, but that's still, that archiver still is subject to open records requests, right?
Exactly. Yep. And I'm gonna talk briefly about open records next, but that's exactly the point. So you still have them. They're still there, and you know, if litigation ultimately ends up in federal court, you probably have to turn them over eventually. But it gives you a first line of defense with, you know, if you're running 15 different areas that store kids' informations at every grade level, you're going to get so out of whack of trying to keep track of where all this information is and what is a student record and what's not. You know, technically, you know, with all that information, you should be going through destruction procedures and things like that when you go to destroy that. If you say up front, we don't maintain all of this stuff's not FERPA information, you have some added benefits. So if a parent says, you know, I want you to change the number of scores that my kid got right on this website, you may not even have the ability to do that. And so by excluding it from FERPA, you're getting it all out of all of the FERPA regulations, their ability not just to inspect it and really go through it, but also to change those records, to attach a statement that they disagree with a certain record. And most importantly, for these emails, not having to necessarily respond to every FERPA request with your emails. So this is not a foolproof way to say, hey, you're never going to have to provide emails in litigation. In fact, the opposite is true. A lot of times in litigation, you are going to be compelled somehow to provide them, whether that's through a subpoena, whether that's through some other legal mechanism. But in that area prior to litigation, if it's just a parent requesting something, you can point to your policy and say, emails are not student records unless we've specifically saved them. And then part of this is having a mechanism so that your teachers can save emails if they want to save them. And so a lot of times that is, through Google Drive or through their email server, their Microsoft Exchange email server, something like that, having a mechanism where they can save emails if they want to be able to save emails. This is complicated stuff, this cognitive dissonance on this. Are there other questions about kind of how to treat emails? Let me
Yeah,
add
I have one more.
Yeah.
If we determine that we're going to provide them the emails in an electronic format, so the combined output of the search from the archiver.
Yeah.
I don't know a good way to redact information in that electronic copy if there's another student's information in that email.
Yeah.
But if they request them electronically, do we have the right to say no because we can't redact?
Yeah, you can do that under the FERPA law. The FERPA law doesn't require that it be in any particular format. I can tell you that at least through our law firm, the school districts provide the documents to us electronically, and we use a particular software product to go through, mark the ones that are relevant and not relevant. So we remove ones that are, say, like a list of every kid who's getting free and reduced school lunch or something like that. And then we also go through and redact things that need to be redacted, and then we can export it in a redacted electronic form. So depending on if you're doing the reviewing or if counsel's doing the reviewing or something like that, there may be a way to do it. But if it's just a parent requesting it from you, ultimately, you can print them all out and put black marker through it. And if they want it, in an Outlook file or something like that, you're going to say, no, we can't do that. And the reason that you can't is because you have to protect the other students' privacy. Let me briefly just address, because I know this is a question a lot of people have, is how long to maintain emails. So just wanted to add that in here. This is a frequent area of disagreement, and a lot of districts do a lot of different things. We've settled on a 3-year time period for archivers. That's based upon a general 2-year statute of limitations for a lot of different types of cases. And then they have an additional 90 days to serve you with a complaint. So you may not know of a lawsuit until midway through the 2+ years. So you're into the 3rd year before you know. So we've said 3 years. Some districts want to maintain them longer. Some special ed cases do now go back longer than 2 or 3 years. And so school districts may say, well, we want to be able to show what we were doing, those years ago on email. And some districts say, we want to get rid of them as soon as possible because it shows, incompetence all over the place. We don't want these things around. So in my experience, sometimes emails help you, sometimes they hurt you. It's a judgment call, but we've generally recommended 3 years, and thus far that has served us generally fairly well. Any other questions on that stuff? All right. So apart from emails, if a parent is requesting all their student records, we need to think about the different places that we're storing things. So what if your teachers are storing things in a Dropbox account that you don't necessarily know about, or they're storing things in Google Drive that we do know about, but are we going to search these different places? And this is one of those proactive things in thinking about student privacy and student records, is thinking about all the places where we're keeping things and containing things. So do you want to let your teachers use Evernote accounts or Dropbox accounts or OneNote or things like that because it's a great productivity tool? But then when we get requests, we're going to have to either go back to the teacher and say we need everything, or we're going to have to go back and get it. So for some of these things, it may be that you need to adopt a cloud storage option for your district, like Google Drive or some sort of box cloud drive or something like that, so that you don't have thumb drives flying around all over the place, things like that. But ultimately, if you're getting records requests, if you're getting litigation requests, if you're getting litigation holds, all of these documents are potentially subsumed in that. And we're responsible for getting them, maintaining them, and having control over them, making sure they're not changed. So in today's kind of computing environment, we've got records scattered all over the place, and they're so frequently are still covered by FERPA. So wherever we can kind of put through procedures or policies or things like that, put limits on where these FERPA documents are stored, it's really advantageous. So another one of those is records stored on a mobile device. One of the things that we've done through our Education Technology Pool Council is we don't just have a student mobile device policy, we also have a mobile device policy for employees. So that is governing their, much like a student who brings their own device to school, it's covering employee devices like iPads and iPhones and Androids and stuff like that that they are bringing to school. And one of the things that we say in that policy is, under no circumstances should sensitive data, sensitive personal information be stored on the hard drive of a mobile device, or on the hard drive of whether that's a laptop, whether it's a phone or things like that. So trying to move toward cloud-based storage and making sure those devices have passcodes on them to try to safeguard student personal information, employee personal information. So that's kind of your opportunity through an employee mobile device policy to say, hey, we're going to put some limits on where data is stored. We don't want it in, on the hard drive of your laptop. Because ultimately, if that laptop goes missing or stolen or things like that, we may not be able to recover that data in the way we could if it were our own, or if it was, encrypted in the way we might encrypt our laptops. And then finally, records stored by the student. One of the areas that's rarely considered in these student record requests is, what about things that are maintained by and stored by the student? So I work with a lot of districts now who have given kids one-to-one devices, whether they're MacBooks or Chromebooks or things like that. And so kids are storing lots of their own data through cloud storage, through Google Drive, things like that. And so normally, these records are not going to be FERPA records. Because remember, the definition of a FERPA record is it contains personally identifiable information and it's maintained by the district. If it's maintained by the student, it's not going to be a FERPA record. So there may be occasions when the one-to-one device provides access to our storage, but normally we don't necessarily have to search the district storage, the student's storage for any of these FERPA records. All right, before I go on to HIPAA, are there any, I know I'm blazing through some of this stuff. Are there any questions about some of this FERPA stuff? All right, a couple more things. This is a really short one. A lot of times I get questions about HIPAA, and this primarily comes from school nurses, and school nurses go to these conferences and they hear about HIPAA and they get very worried about HIPAA privacy rules, which are a bit more onerous. HIPAA applies, it's very much like FERPA, but it applies to healthcare providers that transmit health information in electronic form. So it's the same thing. Patients have the right to examine their records, and the privacy require entities to protect the health records from outside individuals. What you generally need to know in the education environment is this, and I've included this helpful picture to help you remember the rules here, is that FERPA trumps HIPAA, okay? This is the way to remember, FERPA trumps HIPAA. So at a school psychologist office or a psychiatrist office, that document is covered by HIPAA. At a psychiatrist's office, it's a HIPAA document. If the school district requests it and gets that and it's sent to the school district, the minute we receive it, it becomes a FERPA document instead of a HIPAA document, and the FERPA regulations take over from there. So HIPAA has what we call a carve out for FERPA records. So all you need to know, unless you're running some sort of health clinic through your school where you are billing health agencies, is that you're probably just going to be covered by FERPA when it comes to student records. All right, really briefly, I wanted to mention the right to know law. This isn't right on point with student privacy, but it kind of ties into exactly what we were just talking about. Keep in mind, all agency records are public unless we can prove they're exempt. It kind of, turns that the strong presumption is we're going to have to turn over everything unless it falls into an exception. So the key with right to know law is a written request must identify the records sought with specificity to enable the agency to ascertain what record is being sought. So some notes on this is we're not required to create any records for right to know. We're not required to compile, format, or organize records. This is just things that exist. Here too, you may have to redact certain information. We don't have to provide things that would jeopardize network security, but it's a really short timeline. It's only 5 days to respond. If you give notice that you need legal review, you can get an extra 30 days. But still, 35 days is a really tight timeline to turn on some of these requests. One of the reasons I wanted to bring this up here is that right to know is slightly different because it requires you to provide the document in the medium requested if it exists in that medium. So this is different than FERPA. In FERPA, I said, hey, if they requested it electronically, you have to redact it. You can give it in paper form. Under right to know, if they request it electronically, you have to provide it. So documents with metadata, they might, they don't want you to PDF it. They may want it in the original form so that they can find out who the author is. They can find out how many times what the editing history is, things like that. So ultimately, right to know is in the medium requested if it exists. So here's just an example. The ACLU suspects the school district's blocking access to LGBT websites through its filtering. The school principal is very active with the local anti-gay group outside of school. So the ACLU submits a right to know request for all information related to the district's filters. This is real setting. I don't know if you guys have experienced this, but the ACLU has been making a number of these requests statewide. So let me just walk through this example really quickly. So one of the questions here is, okay, they've requested the filtering information. Is that going to jeopardize network security? For the most part, it won't. So you may just have to provide that in the format it's requested. Now, a key about right to know law is it doesn't necessarily require you to make copies. The law requires you to provide access to the documents. A lot of times it's going to mean making copies because it's easier. You don't want these people sitting in your office all day. But for certain records or certain ways that things might be configured, you may not want to provide them that way. I wanted to mention this new case which came down about a year and a half ago called Paint Township versus Clark. And this is a new decision under the Open Records Law, which found that records stored on a township supervisor's personal cell phone must be produced pursuant to right to know law. So this is again concerning where we store data. Are we storing it on personal phones? Are we storing it on cloud drives, things like that? And this follows up an earlier decision a couple years ago, which found that emails stored in a Yahoo email account that were related to official government business had to be produced under right to know law. So what the courts have been saying is, we don't really care where it's stored. If it meets the definition of a record under open records law, you got to turn it over. So they don't really care if it's on a personal phone. They don't care if it's a personal email account, because what the court said is, if that were the rule, all we would be left with was people using personal email and personal accounts. No one would ever use their government accounts. They just get around the right to know law by doing this. So since I mentioned Trump in the HIPAA slide, this is really the Hillary Clinton email server question, which is, it doesn't really save you that you use your personal email. If it's government business, you're going to have to turn those emails over. So ultimately, this is kind of in the big picture of where we're storing data and how we're storing data. Wherever possible, we want to maintain control. So you think about on the margins of some of the places where this might be an issue. Do your school board members use school district email accounts, or do they use their personal accounts? That's a frequent area where there could be a transaction of the agency that takes place in email that we have no control over, that we're not going to be able to capture through our archiver, that we're going to have to get access to, maybe not just their personal account, but maybe that school board member's work account. And you think about some of how cumbersome that could be. So this is really an area where the law is still developing. Right to know law is only about 6 years old. But so far, the courts have been very open in their interpretation of where records are stored. They don't really care. What we're left with is a strong presumption that everything's going to be an open record, and we may have to produce it. So one other area I wanted to mention in this, which is a frequent area of questions, is school surveillance video. This one's not entirely clear whether it is a FERPA record, whether it is an open record, but there will often be some sort of incident on school property. So a kid is restrained by an administrator, or there's a fight, and a parent says, I want to see the video for myself. And so they send a letter or whatever, they demand that they see the video. Well, a couple things. One is, remember that under both FERPA and Right to Know, you don't have to provide a copy. You can simply bring them in to view it at school. They can inspect it at school. But the second thing is, if it has been pooled, we pool the video surveillance because it's a disciplinary matter or something like that, it will be a FERPA record ultimately at that point, because it's related to discipline. It's a video of the occurrence, and it's probably going to be the type of thing that a parent can inspect. It's not like you can redact the other kids out of the video, so they will have the opportunity to see that video in school. But by being smart about that, knowing, okay, I'm going to bring them in to show it instead of giving it to them, we may prevent that video ending up on YouTube or ending up on the local news or something like that. We can kind of be proactive at that. So this is another area where we recommend using policies to really help you. So one of the policies we say is, in addition to your education records policy, where you're kind of laying out what an education record is, we have record retention policies which define what a record is. What is a record that is maintained by the agency? And one of the things we say is, we don't maintain video surveillance unless it has been pooled for some particular type of incident or something like that it's routinely deleted. Are there questions about this stuff?
how do you enforce your records retention policy onto someone's personal device or personal email?
Well, ultimately you can't necessarily on their personal device, which is why wherever possible we're trying to have them use our approved resources through their phone. So instead of they're storing data on their personal phone or whatever, they store it in Google Drive or something like that we maintain access to. So trying to find ways that we still maintain control over as many of the things that are considered records as possible. Now, things like text messages, we don't want to maintain those. We don't want those, so we don't maintain them, and we're better off in our policies to say we don't maintain these things, so that they're not subject to right to know requests. They're not subject to FERPA requests because we don't maintain them, and then we can just point to our policy ahead of time and say we don't maintain these things. Any other questions on this? Okay, I'm going to blow through this really quickly. The Federal Rules of Civil Procedure, I just wanted to emphasize the main rule from this is that through discovery in federal court, if you ever get involved in federal civil rights cases, if any of your special ed cases go to federal court, just know that generally you can be ordered to produce anything. And so that could include producing your computers, it could include producing emails, it could anything that's relevant could have to be produced. So ultimately, the more that we can control things, the better, rather than us having to compel our employees to turn over their personal cell phones, their personal iPads, their personal laptops. If we have control over it in these litigation cases, we can then control, okay, we can get it back. So ultimately, you may be asked to, provide documents, answers to questions, things like that, and it could be quite cumbersome on a tight timeline. Okay, so I'm going to move through this pretty quickly. All right, the last thing I wanted to address with you before we run out of time here is searching student devices. And this is another area of student privacy. And just remember, the general rule is that students have a right to be free from unreasonable searches and seizures. So consider this example. There's a fight in the bathroom with 2 boys, but there were 5 boys in the bathroom watching. In the course of the investigation, the principal finds out that one of the boys took a video of the fight. Assuming this is the kid's own phone, can the principal take the phone and search the phone? So I just mentioned students have a right to be free from an unreasonable search. And the law on searches has generally been the same since 1985. It's the same as searching a kid's backpack, searching a kid's jacket, any kind of personal things that we're searching of a kid. A phone is the same. Ordinarily, it's justified if there's reasonable grounds for suspecting that the search is going to turn up evidence. So we have to think we're going to get evidence that the student violated or is violating the law or the rules of the school. This is from a 1985 case, New Jersey versus TLO. So we have to think we're going to get evidence. But there's some exceptions here. You can't search a phone to find evidence of another student's misconduct. And this is the Clump versus Nazareth area case from 2006. And in this case, what had happened is in 2006, I don't think I'll surprise everyone, most districts were still banning students from having their own phones in school. And a kid had his phone in school, and the teacher saw that he had his phone in school, and so they seized the phone for essentially violating school policy of having his phone. Now, at that point, does the principal who has taken that phone have any reasonable belief that searching that phone is going to turn up evidence of violating the law or the rules of the school? No. The violation was having the phone, and he had the phone. But those administrators decided to go into the phone and start searching the phone. And actually what they did is they started contacting people in his contact list to try to find out who else in school had their phone on them. So making phone calls like a Trojan horse operation, calling the other students to find out who else had their phones. And so ultimately, it was a giant mess of a lawsuit. The administrators got sued in their personal capacity, and it was alleged wiretap violations under state law. It was really a debacle. But the lesson that came out of that case is you can't search this kid's phone to find evidence of another student's misconduct. So you have to have a reasonable belief that the search is going to reveal evidence of the kid who you are searching. And then a corollary to that is that the scope of the search has to be reasonable. So when I'm talking to administrators, I'm talking to them about searching, a lot of times there's allegations of inappropriate photo or something like that on the kid's phone. Well, that may get you into the photos, and it may even get you into like Instagram or something like that. But it doesn't necessarily get you into reading all the kids' text messages. It doesn't get into going through all the kids' emails. It's not like once you're in the phone, you can go everywhere. So the scope of the search has to remain reasonable, and it's not just a fishing expedition. Easy for me to say. So back to the hypothetical and what I'd mentioned. So the principal finds out one of the students in the bathroom caught the incident on video. Maybe the principal sees it. Well, now remember, if the rule is you can't search a kid's phone to find evidence of another kid's wrongdoing, do we have reason to believe by searching this phone we'll find evidence of wrongdoing by the videographer, the person who took the video? Well, if your school rules prohibit videoing in bathrooms, then yes, you can search it because you're going to find evidence that the kid was videoing in the bathroom or taking photos in the bathroom. I actually think there's another reason you can do this is because I don't think it was an accident that the other kids ended up in the bathroom. I think that they were probably in on the conspiracy to show up there at the same time. So I think probably regardless, you can search this phone, and then once you see that video, you can use it against all the kids involved. So once you have it, you can use it against everyone. But you can't just go up to an innocent kid who has not done anything wrong and say, I've heard that you have something on your phone that I might be able to use against this other kid. I need your phone. I'm demanding your phone. That's going to be an unreasonable search and seizure. So the analysis you should do, and this is what you should work with your principals to make sure they know, do I have a reasonable belief that searching this phone will reveal evidence that this student violated either the law or the rules of the school? So in this case, I say yes, and the principal may search the phone, limited to the pictures, videos. Now, I've put an asterisk next to reasonable belief because of one new case, which I'm going to talk about in a second. But a couple questions that usually come up, I just wanted to mention, there's no expectation of privacy in lost property. So if school teacher, school administrator find a phone, they can lawfully search the phone to ascertain its owner. That's fine. And it's also an exception to get consent. So asking a kid if they will consent to a search of the phone may lead to a lawful search. One of the key concerns in this is consent can't be coerced. When looking at whether consent is coerced, it's generally, they look at all the circumstances surrounding it. Is it 3 administrators standing over a little 3rd grader who's terrified, and are they saying, your mom would be really disappointed in you if you didn't allow us to search this phone? The kid's, hysterically crying. That's going to be coerced consent. But if it's a single administrator talking to the kid in a non-threatening way, everybody's sitting, and the administrator said, hey, I heard you have this on your phone. Would you mind showing me what you have on your phone? And the kid keys the phone and shows the principal. That's going to be a lawful search. So that's the type of language that I like to use. Would you mind showing me? That is how you're likely to get lawful consent. if parents are paying for the phone and the parent owns the phone, you can also call the parents and get consent from the parents to search the phone. So there are different avenues here to get consent to search a kid's phone. Just a couple things to keep in mind. I mentioned the wiretap concerns. Intercepting an electronic communication that's meant for someone else is illegal in Pennsylvania. So never intercept text messages, never intercept phone calls and pretend to be someone else or something. You think that you're going to uncover the drug deal of the century. Let the cops worry about that. It is a crime to intercept communications. Now, if a phone is sitting on the principal's desk and a text message pops up and they happen to see it, that's not unlawful interception. But just know that we can't pretend that we are someone else in order to communicate via text message or email or something like that. It's also a crime to exceed authorization in electronic storage. So going through a kid's text messages, going through a kid's emails, things like that, without consent is a crime in Pennsylvania. So be aware of it. It's, sometimes administrators get ahead of themselves when trying to uncover wrongdoing. So strongly advise against that if that's happening. So a couple of final words here about one-to-one devices. If we have given kids a device, it is like us giving them a locker, giving them a textbook. It remains our property in almost every acceptable use policy. I know our model acceptable use policy says students do not have any expectation of privacy in school district technology. Even though we say that, students still have some very small limited expectations of privacy. They have an expectation that you're not going to remotely turn on their video camera. They have an expectation that you're not going to remotely listen in on their conversations with the microphone that's located on the laptop or something like that. They have a limited expectation that you're not going to demand and do a search without any suspicion of any kind. So even though we have said there's no expectation of privacy, a student can still argue they have ever so small of an expectation. So generally, you're only going to search a one-to-one device unless you have some sort of belief that there's inappropriate material or contraband or some sort of violation of the rules. That's the general rule. You're not going to just demand all 20 kids turn in their devices so you can search them just to make sure. You're generally going to have some reason. And then the last thing I wanted to mention here is there was a recent case called Riley versus California from the Supreme Court, the U.S. Supreme Court, which found that there is a heightened level of expectation of privacy in mobile phones. So in this case, a police officer went through a guy's phone, found that he was involved in a gang shooting. He was charged with this gang shooting, and the Supreme Court overturned his conviction, saying the search was illegal because the guy had an expectation of privacy in his phone. The police should have gotten a warrant. So this doesn't overrule any of our legal standards about being able to search a kid's phone or being able to search a one-to-one device or anything like that. But just know the Supreme Court's not really concerned about remote wiping or the destruction of evidence. They're more concerned about privacy of these mobile phones. The Supreme Court went into extensive detail about how mobile phones contain so much information about kids' lives, about people's lives, whether it's their contacts, their friends, their communications, their health data, things like that. There is a heightened expectation of privacy in mobile devices. So we really just need to be careful about when we're going to search. So if you're not 100% sure, you're not sure what's, if you should go forward, it's a great opportunity to consult with your solicitors, consult with counsel, and make sure that you're on square legal ground before you go forward with any type of search. All right, I think we're just about out of time. I have a handful of minutes if there are any questions about any of these topics. I know that some of this stuff's like drinking from the fire hose. It comes fast and it comes furious. But You know, I'm happy to answer any questions about it that you may have.
Going back to open records, you know, if someone's sending something through a personal email and they delete it in their personal email, usually the service provider does retain evidence of emails, like they do archive to some degree. Couldn't you submit an open records request to that provider to turn that over even though the person had deleted it?
Well, ultimately, I don't think it would necessarily be our responsibility as a district. It would probably be on the, you know, unless we're involved in litigation or something like that. If it's just a simple open records request, our job is to go through all of the things we control and see whether we have it. And ultimately, if we don't have it, we respond back that we don't have it. Now, when I say all of the things we control, this is the dangerous area, that also includes our employees, you know, may include their personal devices because we control our employees. So when we have to find out if we have it, we check all of our things first. But if they're requesting something specific from a specific person, we may have to check with them and say, do you have this? If they say, no, we don't have it, you just respond back that, you know, no such document exists. We don't have to maintain such a document. If they want to take it further into the courts, it may be that a court order to Google or Yahoo or something like that uncovers some evidence of it, but it's not necessarily something that we worry about till we get in litigation. It's not like the school district has the authority to just submit a request to Google for some private email account. That'll just be denied. Are there any other questions? All right, hearing none, I thank you guys so much for your attention, for your questions. These are great questions. Again, the slides are at tinyurl.com/WIU-JAN21, JAN21. And if there are other things that I can assist you with or help you with, you can find me at sweetstevens.com. And hopefully I'll be talking to you all again very shortly. So thanks so much, guys.
Thanks, Mark.
Have a great day.
You too.